Some breaking news here. The D.C. Court of Appeals has returned a unanimous ruling that Donald Trump does not have presidential immunity, in a huge win for both Jack Smith and also people who generally enjoy living in a democracy. As part of the 57-page rebuke to Donald Trump, the judges wrote, "We cannot accept former President Trump's claim that a president has unbound authority to commit crimes that would neutralize the most fundamental check on executive power, the recognition and implementation of election results." They went on to say, former President Trump's stance would collapse our system of separated powers by placing the president beyond the reach of all three branches. Presidential immunity against federal indictment would mean that, as to the president, the Congress would not legislate, the executive could not prosecute, and the judiciary could not review. We cannot accept that the office of the presidency places its former occupants above the law for all time thereafter. Careful evaluations of these concerns leads us to conclude that there is no functional justification for immunizing former presidents from federal prosecution in general, or for immunizing former President Trump from the specific charges in the indictment. Scathing would be an understatement. This case centers on the absurd notion that Donald Trump had complete and total immunity to do whatever he wanted as president, even if that meant committing crimes, and is therefore protected from criminal prosecution. In effect, he's suggesting that a president is above the law, and that the office of the presidency gives him carte blanche to do whatever he wanted, even have his political opponent assassinated if he so chooses. And I'm not being facetious, because that is quite literally what his own lawyer argued to this very appeals court.
Order SEAL Team 6 to assassinate a political rival. That's an official act in order to SEAL Team 6?
He would have to be, and would speedily be, impeached and convicted before the criminal prosecution.
What if he weren't? There would be no criminal prosecution, no criminal liability for that?
Chief Justice's opinion in Marbury against Madison and our Constitutional tradition and the plain language of the impeachment judgment clause all clearly presuppose that what the founders were concerned about was not.
I asked you a yes or no question. Could a president who ordered SEAL Team 6 to assassinate a political rival who was not impeached, would he be subject to criminal prosecution?
If he were impeached and convicted first. And
so your answer is no.
My answer is qualified yes. There's a political process that would have to occur under the structure of our Constitution, which would require impeachment and conviction by the Senate. In these exceptional cases, as the OLC memo itself points out from the Department of Justice, you'd expect a speedy impeachment and conviction. But what the founders were much more worried about than using criminal prosecution to discipline presidents was what James Madison calls in Federalist Number 47, the newfangled and artificial treasons. They were much more concerned about the abuse of the criminal process for political purposes to disable the presidency from factions and political opponents. And of course, that's exactly what we see in this case.
I've asked you a series of hypotheticals about criminal actions that could be taken by a president and could be considered official acts. And I've asked you, would such a president be subject to criminal prosecution if he's not impeached or convicted? And your answer, your yes or no answer is no.
I believe I said qualified yes if he's impeached and convicted first. We may be saying the same thing.
My question was, okay, so he's not impeached or convicted. Let's put that aside. You're saying a president could sell pardons, could sell military secrets, could order SEAL Team 6 to assassinate a political rival.
Sale of military secrets strikes me as something that might not be held to be an official act. The sale of pardons is something that's come up historically and was not prosecuted.
But your brief says that.
So yeah, if you're wondering how we ended up with a scathing, unanimous 57-page ruling completely rebuking Trump, that moment might help explain things. Now, in terms of appeals, the judges on this appeals court have put their decision on hold until Monday to give Trump time to appeal to the Supreme Court if he chooses, which of course he'll do. And keep in mind that this decision was handed down by a 3-judge panel, one which included a judge who sided with Trump in the past, mind you, so it's still possible that Trump could appeal also for en banc review, meaning he'll ask the entire D.C. Court of Appeals to weigh in, as opposed to just this panel, which he'll likely also do as a means to further delay sending that question back to the trial court judge, Judge Chutkan. I asked my Legal Breakdown co-host Glenn Kirshner about that process. Here's what he had to say.
After we get the opinion from the 3 appellate court judges, then Trump will have the opportunity to file for an en banc review, which means all of the appellate court judges sitting in judgment of the case. It's like a rehearing, a second shot, a second bite at the apple. And there are 11 federal judges on the D.C. Federal Circuit Court of Appeals. Here's the good news, Brian. Trump just tried this recently in the gag order case where 3 judges shot him down, and then he sought to have the full bench review, and all 11 judges shot him down and said, we're not even voting in favor of rehearing your case. So I think there is a little bit of light at the end of the tunnel. But you also make a great point. You say that Donald Trump will inevitably appeal this to the Supreme Court. I agree with you. But here's the thing. The Supreme Court does not have to accept review. So the 3 judges could issue their opinion. Donald Trump could seek to have the Supreme Court review it, and they could say no. And they should say no, because there is no constitutional support. None, not one word supporting the notion that a president can't be held accountable for his crimes.
Now, of course, the question becomes, what happens to the March 4th trial date? Here again is Glenn Kirshner.
So, all hope is not lost that we can still get the DC trial, moving forward in the direction of a trial date. But there's been some news that suggests the March 4 trial date, just about a month from now, is pretty much all but lost, because there's a public docket which sets out future trial dates. New reporting says that the March 4 trial date that was on the public docket previously has fallen off the public docket. Not a surprise, but a sure sign that we're not going to trial in DC on March 4th.
Now, depending on how quickly the Supreme Court rules on this when it's inevitably appealed, it is absolutely still possible for Judge Chutkan to resume this trial before the election. We've contended with a 28-day delay thus far to allow for the DC Court of Appeals to weigh in. If Trump wants to try and get en banc review, it's possible that the judges could refuse to hear it immediately, and as Glenn mentioned, it's also possible that the Supreme Court could refuse to hear it. Or, just as likely, they could take up the question and definitively swat it down, just as the DC Court of Appeals has done. In any case, while March 4th specifically won't happen, we could see the case resume in May, for example. Consider this, we've all been expecting the Florida classified documents trial to be pushed because it's being presided over by Judge Aileen Cannon, who is an avowed Trump loyalist who's already interfered in court proceedings on his behalf. If she tries to help Donald Trump by pushing that trial date back, then suddenly May 20th becomes available. And if Judge Chutkan sees that, and the Supreme Court's already ruled in the same way that the DC Court of Appeals has, then Chutkan can quite simply move her case into that newly opened slot. So while Judge Cannon may, per usual, seek to help Donald Trump, all she may be doing is handing another judge a nice big opening to begin his prosecution. Meanwhile, we should celebrate the fact that the appeals court has ruled the way it has, definitively finding that despite Donald Trump's claims to the contrary, no, a president is not above the law. But what should be worrisome is that the Republican Party's likely nominee is out there suggesting that he's essentially akin to a king, that he is above the law, and that he views the presidency, the role that he is seeking right now, as a literal get-out-of-jail-free card. The fact that the self-proclaimed party of the Constitution is now rallying behind a despot who wants total control and total power goes to show that it was never about the rule of law and was always about consolidating power under the pretense of gauzy buzzwords like the Constitution. If there was any way for the GOP to be any more hostile to the Constitution, I couldn't figure it out. So we'll continue to keep an eye on this case, but some decidedly good news from the DC Court of Appeals unanimously declaring that despite his best efforts, no, Donald Trump is not above the law. Before you go, I need some help. Please subscribe to the channel and do your part to help grow the progressive media ecosystem. I don't do sponsorships or paid ads, I won't ask for money, but just subscribing to this channel goes a really long way, and it helps get the message out to more people. The subscribe button is right here on the screen. You can also subscribe to my Spanish language channel, which I made to reach those crucial Spanish-speaking voters. That link is on the screen too. And finally, if you want to listen to my audio podcast, you can follow that link as well. Thanks so much for watching.